Contract of Sales of Goods Act 1930. Introduction. The law relating to sale and purchase of goods prior to 1930 were dealt by the Indian Contract Act 1872. In 1930, Section 76 to 123 of the Contract Act was repealed and a separate act known as the Sales of Goods Act 1930 was passed. Definition of the contract of sale. According to the Section 4 of the Sale of Goods Act 1930, a contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a price. A contract of sales consists of the following: sale and agreement to sale. Essentials of contract of sales. The following essential elements that are necessary for the contract of sale are: first is two parties. There should be a bilateral contract in which two parties should be there. Second is goods. The goods must be movable. Third, price. The commodity should have a price. Fourth, transfer of ownership of property. Fifth, essential elements of a valid contract should be there in this contract. Goods. Goods means every kind of movable property other than actionable claims and money. It includes stock and shares, growing crops, grass, and things attached to or forming part of the land. Are agreed to be served before sale or under the contract of sale, section 2 of 7. Classification of goods. There are three types of goods. First is existing goods. Existing goods means the goods which are owned or passed by the seller at the time of contract of sale. Existing goods are classified into three. A is specific goods. Specific goods are those goods which are identified and agreed upon at the time of contract of sale are made. B is ascertained goods. Goods are said to be ascertained when out of means of ascertained goods, the quantity extracted for it is identified for a given contract. C is unascertained goods. There are the goods which are not identified and agreed upon at the time of contract of sale. For example, 20 television sets are unascertained goods before the identification of a particular television to be sold. Second is future goods. Future goods means goods to be manufactured or produced or acquired by the seller after making of the contract of sale. Third is contingent goods. The goods, the acquisition of which by the seller depends upon a contingent event which may or may not happen. The price. Price means the money consideration for a sale of goods. Price can be fixed in the following ways: by the contract or terms of agreement, or may be determined by course of dealing between the parties, or it may be the price prevailing on a particular day. Conditions and warranty. Important terms. Representation. Representation means statement made by the seller before entering into a contract. Stipulation. If such representation forms an integral part of the contract and other party relies upon it. No representation. Caveat emptor. It is, let the buyer be aware, is implied in conditions and warranty. Conditions. A condition is a stipulation essential to the main purpose of the contract, the breach of which gives rise to a right to treat the contract as repudiated. It goes to the root of the contract. Its non-fulfillment upsets the very basis of the contract. Hence, the breach of the condition gives rise to the agree to a party a right to terminate the contract. Warranty. A warranty is a stipulation collateral to the main purpose of the contract, the breach of which gives rise to a claim for damages but not right to reject the goods and treat the contract as repudiated. Distinguish between condition and warranty. In condition essential of the main purpose of contract, warranty stipulations which is collateral to the main purpose of the contract. In case of breach of a condition, the aggrieved party can repudiate the contract of sale. In case of breach of warranty, the aggrieved party can claim damages only. A breach of condition may be treated as breach of warranty. The breach of warranty cannot be treated as a breach of a condition. Rights of unpaid seller. Unpaid seller. A seller of goods is deemed to be an unpaid seller when the whole of the price has not been paid or tendered, a bill of exchange or other negotiable instrument has been received as a conditional payment and the condition on which it was received has not been fulfilled by reason of the dishonor of the instrument or otherwise. Conditions of unpaid seller. The term seller includes any person who is in the position of a seller. The seller shall be called an unpaid seller even when only a small portion of the price is unpaid. It is for the non-payment of the price and not for other expenses that a seller is termed as an unpaid seller. Where the goods have been sold on credit, the seller cannot be called as an unpaid seller. Rights of an unpaid seller. An unpaid seller has two rights. First is against the goods. Where the property in the goods has passed, lien on goods, a right of stoppage in transit, a right of resale. Where the property in the goods has not passed, withholding delivery, stoppage in transit. Second is right against the buyer personally. A. Suit for price. B. Suit for damages. C. Repudiation of contract. D. Suit for interest. Thank you.